Your Honor, I'm worried about her coming after me because I was at the Legion one time. If it hadn't been for a friend of mine, I told her to leave me alone. And she kept coming, and a friend of mine stepped between us and stopped her. And I'm afraid she's going to come.
Your Honor, that is total ridiculous.
Whoa,
I tried to
Talk to her, and this other friend tried to stop me from talking to her, but I never came after her.
Goats. Her, yes.
What's up, court nerds? Time to get served, and I know it's been a while, but I thought an old school intro was long overdue, so let's get into it. Today's clips are straight out of Jefferson County, Texas, and I don't know why these defendants think that absconding and constantly violating probation would ever fly in Judge Stevens' courtroom. However, they just keep doing it. And in time served style, I threw in an extra clip from Judge Mark Nelson. Don't forget to hit that like and subscribe, set your notifications to all, and never miss the daily docket. I'm Time, and you've been served. Let's roll, nerds.
Me back and forth. One locks me up, lets me go. I go get a beer and come out, and I'm getting locked up by the other person. I'm like, damn, I didn't even get a chance to breathe before I even got out the door, before I even cracked one open and you got me again. I'm not a bad person. I live in Southwest Detroit. I'm used to living in another neighborhood. And I moved out here and I noticed that the atmosphere is a little more like direct, and they're on me, and I don't even know nobody. I don't have any friends. I don't have nothing. I don't have no girlfriend. I have my daughters. I haven't seen my 3 daughters, and I've been stressed out. So, and it ain't your guys' fault. It is my fault. And I just know that I haven't been drinking though. I drank the other day like half of a bottle, and I haven't drank in like a whole year. And I know that I didn't even I don't know. I'm not drinking though. I haven't been drinking like that. I've been faking drinking, but I haven't been drinking. I've been fake drinking. I haven't had no real good drink since I don't know when, and it doesn't even crave. I don't even get the craving. My stomach hurts now. I'm hungry. I don't know. I don't even think about drinking. It's weird. This stuff's going on. I'm trying to.
Okay, I heard a lot, sir, but I didn't hear why you weren't in court on May of 2022.
I didn't live here. I lived in Southwest Detroit.
I'm sorry?
My house got set on fire. It was on the news. It was on the news on Southwest Detroit, right on the corner from Church's Chicken and on Central and
Sir, please pause. Okay, your home may have caught fire. It may have been on the news. We do not keep track of individual homes that catch fire to see whether or not somebody lives at that home that has a case here in the court. If you had to go stay somewhere else, it's your responsibility to notify the court of a new address. However, we have your address in Lincoln Park. So where do you live?
642.
Much board dire and everything else.
Yes. I'm ready to ask those your questions.
And probation is here. Oh, first amended, I guess, is what.
Yes, sir. And on the first amended, it's
got an offense.
5 and 6 are actually the same evading. They're 2 different counties. I think I can only charge 1.
So
we'll do number 6, which is in Jefferson County. That's the one he's pleading true to on these. The aggravated assault on a peace officer is the one we're going to have to try.
Okay.
So we're just going to plead on one of these because that's actually the same offense going through 2 different counties on 5 and 6. So we'll plead on 6.
We now call. Everybody ready? Clause number 21-37687. The state of Texas versus Tony, is it Tyrell Duhan?
Yes, sir.
The defendant is present with Miss McElheen.
his fine attorney and the state's attorney. Does the defendant waive a formal reading of this first amended motion to revoke probation, which was filed June 16th of this year? Can we proceed in summary?
Yes, sir.
And Mr. Duhan, raise your right hand. Do you solemnly swear or affirm that the testimony that you were about to give in this hearing will be the truth, the whole truth, and nothing but the truth? So help you God. Lower your hand. In summary, this motion states that and it's a first amended motion to revoke probation, states that on January 19th, 2022, that would have been going on 2 years, almost 2 years ago, that you were sentenced to 10 years in prison, probated for 10 years for evading detention with a motor vehicle, which was a third degree felony. Is all of that true and correct? That's true. You were sentenced to 10 years, then that was suspended and you were placed on 10 years probation. Number 5. Number 6. We're going to do
6. Yes, sir.
Number 6 allegation states you committed the offense of evading arrest or detention with a motor vehicle on or about April 14th, 2023 in Jefferson County, Texas, in violation of your probation order. Is that true or untrue?
Yes, sir. True.
Are you pleading true to that allegation?
Yes, sir.
Voluntarily, and because it is true as it is alleged?
Yes, sir.
Do you understand by a knowing and voluntary plea of true to one or more violations of probation, that is enough to grant the motion to revoke probation? Your probation can now be revoked. You can be sentenced to no less than 2 nor more than 10 years confinement in prison.
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir.
Is there a need to go to any others?
No.
Okay, I do want to hear from the probation office a summary of other, notwithstanding violation allegation 6. What else can you tell me about Mr. Duhan's time here?
Yes, sir.
There's no deal on this, right?
Correct.
Okay.
Mr. Duhan was placed on probation in January of last year. Since being placed on probation, he reported to the office a total of 9 times, which ended September 6th of 2022. Since then, he has not reported in person to the department.
Since when?
September of last year.
Of 2022?
Yes, sir.
He's been a goner? He's
Yes,
been
sir.
absconded?
He absconded.
And how long have you been in jail?
That was in April 14th.
April.
Yes, sir.
November through April.
So, did he ever try to explain that?
No, not to me, Your Honor.
Well, excuse me while I eat breakfast and lunch here. It's been a very hectic day. And I'm eating popcorn.
January through
April. You're really not on probation if you're not touching base with us and supervised.
Yes,
I mean, it's really not. It's kind of a joke, and it's not actually supervision, which it's futile for us to have a probation office. You don't report. You have to touch base all the time, and we keep you. Not only are we keeping an eye on you, we're reminding you about all the rules and the consequences of breaking the rules. And the problem here is you're on probation for evading detention with a motor vehicle. And so what do? You go out and commit another crime as though you're not contrite about the first mistake. And the law provides that these are third-degree felonies because when you're evading, I don't know if you were with a motor vehicle, we're talking about cases here that it's not unusual for us to have people fatally injured, seriously injured in car crashes because they happen to get hit by vehicles that are involved in fleeing from an officer. It's very dangerous. And it it really haunts us all for the rest of our life. It haunts us to hear the lamentations of people who go, we were just following the rules. We were minding our own business. And then this car comes out of nowhere at 120 miles an hour and kills a bunch of people. That's what happens. And then you go, well, what can you do about that? You can't undo it. We can't go back in time. But you had to have recognized how important it was the first time we made a big deal about it and been placed you on regular probation because of the serious nature of all of this type of offense. Do you happen to have a pre-sentence report I can look at really quick?
Yes, sir.
Thank you. Yeah. I'm not surprised what I'm reading here. In your criminal history, in the misdemeanor part, for example, you've got an assault. How old are you right now?
35.
You're old enough to know better, but back 15 years ago, 18 years ago, actually 16 years ago, you committed the offense of assault, and that was a misdemeanor conviction. Failure to identify in 08, that was a conviction. Trespassing in 08, that was a conviction. Family assault, and that was in 2010, that was a fine. But here's what I'm leading up to: evading arrest or detention in 2015. And 60 days in jail. So you know we're serious about that. 60 days in jail. But you go back and you commit in 2021 evading detention with a motor vehicle, and then sentenced to 10 years. We made a bigger deal about it. 10 years in prison, probated for 10 years last year. And so now you picked up a third evading with, and this one's second one with a motor vehicle. But I'm not even including these failures to appear, contempt of court, traffic offenses, violation of school compulsory law, possession of drug paraphernalia. I mean, all of those are just all things that just show, hey, I don't take this seriously. And you have to, like I have to, we all, so that we can all live together on this increasingly small planet peacefully and enjoy what our dreams are. But here you are, is back before me for the same offense, third time. And This could have been such a catastrophe. They stop you for expired registration. See, you're not even driving a vehicle with the proper procedure. Everybody else has to pay for inspection stickers and registration, but you're because it's a privilege. You look in the Constitution, what that flag stands for, you won't find you have a right to drive a car. You won't find it in there because it's a privilege. It's not a right. But you got to pay for the privilege like everybody else does for the cost of the roadways and the maintenance, the security, so that we can all enjoy it together. So you were asked to step out of the vehicle. You refused, fled, and as you fled, you ran over the police officer's foot.
And that's the one that we're not reading on at this particular hearing. But
Okay, he doesn't, but the next sentence completes the thought. A vehicle pursuit ensued through Port Arthur and continued in and through the city limits of Beaumont and on to Chambers County. So I'm sorry, but this was 8th Avenue in Port Arthur that this happened, not Chambers County. This is Jefferson. This is the one he pled to. But even if he didn't, this was a series of acts that began in one county and ended in another county, so they're connected. I mean, isn't that true? This is what we're talking about, Port Arthur, Texas, that you pleaded true to here in number 6 in Jefferson County on April 14th. He received medical treatment. Oh. Well, this doesn't look good, obviously. I mean, not only did you do the third thing wrong that we'd already sanctioned you for 3 times, but you ran over you injured a police officer. My goodness.
I didn't do it. It's on the video. It clearly shows that I didn't do it.
he is maintaining that he doesn't believe that he ran over the officer's foot.
All
right.
I seen the video.
Oh, you did? Oh.
He didn't have an injury on his
Okay.
foot at all.
All right, let's walk it back. Let's say you didn't drive over. What are you doing leaving the scene and running from the police? Do you have any excuse for that?
No, sir.
All right. It's a crime. It's a crime. My goodness, it's a felony on my watch after you had gone AWOL on us. That again is something that the court doesn't find amusing. We have 5,000 probationers. We can't go and find you and ask you polite, please come back. You have a responsibility that you signed off. You made a promise to me. Let's see. Here's your signature, Tony. I've received a copy of this order. I agree to follow all conditions imposed. I know that this probation can be revoked for any violation. You know how important that was. Oh. So, what do we do? What's the defense asking for?
We're asking, first of all, he would like to have the opportunity to stay on probation. And even though he realizes he's facing at least the one felony and a second one that he's contesting so far, but he would like the opportunity.
You know,
to
that
stay
other
on.
one in Chambers County, I wouldn't.
No,
I don't think they're going to pursue that. I know it's in the same, wrapped up in the same transaction.
Yes,
but,
sir. The law states that we can only, it's one continuous act, so it can only be charged one time. So it'll just be the one evading.
But we're all clear. It happened here in Jefferson County.
There is the
It started
aggravated
here in Port Arthur,
aggravated assault on a peace officer.
my old birthplace, and so we've got to. We're involved here deeply in the safety of our county.
Yes, sir. And if the court were not inclined to allow him to stay on probation, then we would ask that you consider something that may be on the lower end of the punishment scale, the 2 to 10. He still is facing the aggravated assault case. And, depending on how that comes out, it may affect the length of his time that he might be sentenced today. And did you have anything that you wanted to add on your behalf of why the judge would leave you on probation?
Yes.
What about that probation, the aggravated assault probation?
No, it's a new case.
No, there's a new case, aggravated assault. There's a family violence and this evading
family
detention.
violence. What about that?
We filed a motion in it too. I thought.
Yeah.
It's.
Are we dealing with that today?
Yes, sir. It's
okay.
It's right there underneath your filing. So I think it's there somewhere.
Right here.
The 2 cases you're on probation.
They're both 10 over 10, both 30 degrees.
Why don't we go over that one too? We'll hold this one in abeyance and go to 21-37688. And again, you were still under oath. And does the defendant waive a formal reading of this first amended motion to revoke probation? Can we proceed in summary here?
Yes, sir.
In summary, sir, this motion states that on January 19th, 2022, the same date as the other probation evading detention that we've already dealt with here earlier, that you pleaded guilty and were sentenced to 10 years in prison, probated for 10 years for assault family violence. Is that true?
Yes, sir.
And it's the same. Number 6 is alleged here that you committed the offense of evading arrest or detention with a motor vehicle on or about April 14th, 2023 in Jefferson County, Texas, in violation of number 1 that you had signed off on that probation order, don't commit another crime. And you violated that condition of probation. Is all of that true as it is alleged?
Yes, sir.
Are you pleading true voluntarily and because it is true?
Yes, sir.
You understand by pleading true, that is enough?
Yes, sir.
1 or more violations are enough to grant this motion to revoke probation, the first amended motion to revoke probation, as I would find by a preponderance of the evidence, there is enough evidence to do so. Your probation can be revoked and you can be sentenced as the other case, no less than 2 nor more than 10 years confinement in prison. Knowing that, you insist on pleading true today.
I do.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir.
Anything else?
Just further, we would ask the court.
What is your envision of how this should proceed?
First, did you want to address the court about if you were willing to let you stay on probation, what your plans are?
Yes, ma'am. Well, first off, I have sympathy for the officer if I did, injure him. And second, I was really doing good. My mom passed like September 25th, 2022, and I took in my sister. She's 14 years old. That day, I just made a stupid mistake. I was doing good. I was working, and I just had a lot of stuff to take care of after my mom passed. So I just stopped reporting. I really don't have no excuse.
And what was it that you're saying that happened that kept you from being able to complete your probation requirements?
I just had a lot going on. I didn't really have an excuse. Like I said, my mom passed. I was trying to get funeral arrangements going. It was a lot. And then when I called up there.
Well, when did your mother pass?
September 25th.
Of what year?
2022.
A year ago, last year.
Yes, sir.
Okay. Keep going.
Like I said, I was on the right track. I just made a stupid mistake. I knew I had a warrant for my arrest, and I just ran. I should have just.
A warrant for what?
For the MTRP.
MTRP.
Yeah. God bless you. So, what you're saying is that you chose committing another crime, fleeing, to avoid answering to another violation
Yes,
that was
sir.
being alleged.
Yes, sir.
That's facing your responsibilities in a proper fashion?
No, sir.
No, it's not. That's why it's a crime. Because that's not the way you're supposed to handle issues. All you did is you turned one problem into two.
Yeah, I made it worse.
Yeah, you threw gas on the fire. But you knew it was nobody ever runs forever. They know where you are ultimately. Even if you were able to escape, you're going to get caught.
Yeah, I know.
I mean, it's inevitable. I just can't. I don't know. That happens a lot. I have to face the issues. It would bother my conscience to death if it was. I wonder if somebody's going to walk up my door one day with an arrest warrant for this. I'm not going to wait. I'm going to meet it head on and deal with it responsibly.
Yes,
But
sir.
you've been through this before.
Yeah.
You know how to handle it right versus wrong, but you keep doing it the wrong way. What states?
Judge, this wasn't just a stupid mistake. This was, they clocked him at some points up to 105 miles per hour. He lost a tire, was riding on the rim. They tried to throw out spikes to stop him. He just kept going around everything. And they finally had to actually crash into him with another vehicle to get him to stop.
Is all that true?
Yes, sir.
So we would ask for the 10 years. He's going to hurt somebody, and he needs to know that this is extremely serious.
What would you like to say, sir?
The only thing I'm guilty of is evading, but I do understand if
God bless you. That's not what you're only guilty
no,
for.
by me, I'm saying by me running, I know I caused the police officer to get injured and stuff. Like I could have hurt a lot of people.
We were lucky. They were lucky, not because of you, but the good Lord was shining on and keeping an eye on the people, because the 108 miles an hour does a lot of damage to people when you get hit by a car. You can't. I mean, that's why speed limits are no more than, I think, 80 in the country. I don't think there's one higher than that, which is awfully fast. But still, vehicles most vehicles weren't meant to operate safely at anywhere near 100 miles an hour. Anything else?
Again, I just ask the court to maybe consider holding the motions in abeyance, and he still has this felony to deal with. And then after he's done with that, maybe then it might make a difference on the rest of his probation. Otherwise, if the court's going to revoke his probation, we would ask for something. I don't believe the injuries, the assault family violence was definitely an assault family violence, but I don't think they were severe injuries. And I'm not sure about the evading. Was there a chase in that one? Did anybody get injured in that one? And so I would suggest that perhaps the underlying facts on those two original offenses that he's on probation for don't warrant a full 10-year sentence.
Here's the deal: is your actions speak louder than your words, because you promised me when you were placed on both of these probations that you wouldn't do something like this again, really. Because number one was committing a crime, and you know it's a crime. We made a big deal about it last time. It's a felony offense. So you went right back and did it. You signed off. You made a deal that it didn't take long before you broke with the same crime. If nothing further, I'm going to find in each of these two cases, and this is 21-37687 and 37688, the first amended motions to revoke probation, shall be granted by a preponderance of the evidence or greater, as allegation 6 has been proven true, as the defendant has voluntarily and knowingly admitted to condition 1 violation in each probation, and that is committing the same crime he is on probation for in 37687, the same type of crime, evading arrest or detention with a motor vehicle, which are serious third-degree felonies. In each of these cases, sir, your probation is revoked, and you are now hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years on each case to run concurrently. You put this court into a corner that that you have a problem with, and that is committing the same serious offense, and it just gets worse with irresponsible behavior with a motor vehicle and with law enforcement. The rules don't seem to apply to you. But they do, but you don't accept them. And you must pay a price at this stage for continuously putting yourself and others in harm's way. And again, these 10-year sentences shall run concurrently.
Before he's released back to the jail, may I have a few minutes to speak with him about the third case?
What number is that? That's CR 3474.
Yes. Yeah, 0374.
All right. Okay. Y'all can
Okay.
talk and whatever you need to. David, you ready?
Yes, sir.
Come on, please.
Do you want us to do it? Oh,
However you want to do it. You're with Cesar Marin Serranto.
yes, sir. And he is in custody.
He's in custody.
3 hours later.
Can you move it along? I'm all out of time cards.
Let's bring him out.
He will.
Okay, this is 374, number 374 case.
There.
CR 374, the state of Texas versus Tony Tyrell Duhan, who's present again with his attorney, Ms. Mantalini, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about April 14th, 2023 in Jefferson County, Texas, you committed the first-degree felony of aggravated assault against a public servant with the use and exhibition of a deadly weapon, namely a motor vehicle. Do you understand what you're charged with here?
Yes, sir.
This is a first-degree felony, which means if convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in your case where you would be sentenced, pleading guilty, sentenced to 5 years in prison to run concurrently with other cases. Is that your understanding of the agreement?
Yes,
If I follow, yes.
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney. Are the contents all true and correct? State's Exhibit 1 tendered.
No objection.
It's admitted. Among other things, the state you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is that so?
Yes, sir.
State's Exhibit 1 made a part of the record for all purposes. Pre-sentence report waived.
Yes, sir.
I'm going to follow this agreement then and find you pleading guilty voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first-degree felony as indicted in this case 23 CR 374. You are hereby sentenced in accordance with this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years to run concurrently with other cases. The judgment will show an affirmative finding that a deadly weapon, namely a motor vehicle, was used in the commission of this offense. Anything else? That is all. Thank you. We have anything else, or is that it?
No, we're done.
We're done.
It's here.
Okay.
Yep. We're not going to go start.
What time tomorrow? 9?
9 o'clock. Sir.
9 o'clock tomorrow. What we were gonna do on Ryan. On Ryan Williams. Ryan
He
Keith.
was trying to hire Mr. Paget, told him we didn't have.
Okay, I gave you one file. Here are his other two. There are 3 in total. Okay, here we go.
Judge, if I may.
Hold on.
Okay.
Okay, I have 2 cases here I'm calling. Number 1 is 15-23665. This is a case where the defendant is on probation for burglary of a habitation since 2016. And there looks to be a new first amended motion to revoke unadjudicated probation on that one.
Mhm.
And then we have a new indictment, aggravated robbery, which is included as number 8 in the
Yes, sir.
first amended motion to revoke probation. And when were we here last? Were we here on this?
We were here a few weeks ago.
Yeah.
And you requested, we have requested bond for the MCRP. He's on deferred adjudicated probation. Last week, Mr. Robinson's father tragically passed away, and his family is in the process of funeral arrangements. The funeral is scheduled for this weekend, November 11th. And so this is why it was set on the docket today to see if the court would entertain a bond for Mr. Robinson in any conditions to give him that opportunity to continue and help his family with the arrangements and to obviously attend his father's funeral. I did receive information from the funeral home. It's the RTA funeral home in Houston, Texas. And I asked that they send me a copy of the obituary for the court. And so they were able to send me the proof that they are working on for the funeral. Your Honor, I do have his mother and his mentor, Mr. Todd Roussard, here as well, in which they are assisting me with this. And Your Honor, we're asking that the court set a bond so that Mr. Robinson may be able to attend the funeral and to abide by any and all conditions of bond that the court may set.
This motion to revoke probation originally was filed a year ago, right? And why didn't we ever do anything with that? Does anybody know? That's been just sitting around for over a year.
Yes, sure.
Does anybody know why?
No, sure.
Because 5,000 cases. I can't. And then, which is odd. And then now this, while we've been waiting, now a first amended motion to revoke, including this aggravated robbery that was indicted on August 9th, came up.
And I anticipate you may be able to dispose of that aggravated robbery, Your Honor. I have been in communication with Mr. Laird in regards to some issues with the case.
We're going to have a hearing on the motion to revoke probation as soon as everybody can get ready.
Yes, sir. The concern, I think, is the funeral, the father's funeral is what they were
I just
concerned
want everybody to know.
Yes.
This is fast track. I don't know why that thing sat languishing for a year. I'm going to have to look into that myself because I don't understand that.
But would the court consider a bond in while we
What are we going to do?
that motion?
What are we going to do? He does something irresponsible, like the grand jury said he did.
Mhm.
Who's going to accept responsibility for that next? Who wants to stand up and say, I'm to blame?
He would.
No, don't even raise your hand. The grand jury has spoken here. You're on my watch. I'm answerable for your behavior. I am. And we're going to deal with it quickly. Do you understand?
Judge, would you consider an ankle monitor, or anything else so that they can keep watch if there are any concerns as to his whereabouts? The court consider GPS monitoring.
Y'all want to leave the room? Y'all are either going to testify, but no gesticulations. Somebody got in trouble in the last trial for that. And I didn't even see it, but everybody else saw it. And that's not allowed. This isn't a game show. We're working under rules of evidence, and y'all are in the game right now. Everybody here are the key people.
Yes, sir.
What's state saying? You got a voice in this.
Judge, there's some circumstances around this aggravated robbery that I need to check into. The defendant is willing to potentially take a polygraph to try to clear some matter up. That as long as he has an ankle monitor, home confinement, not objecting to a bond, he is entitled to a bond on the deferred probation.
Who is this person? What is he? How is he related to you?
It's my father.
Mr. Robinson?
Let's see.
So tiny print. So when is the funeral supposed to be?
November 11th.
3 days.
Saturday.
I will allow a release just for that, not for anything else. He's coming back, but he can be released to attend the funeral. He's going to have a GPS device there attached. So we got to get him out for that before. So, but when is it's 3 days.
The funeral's on.
It's in Houston?
In Houston.
All right. So he needs a GPS device on his way out of the jail to Johnny's or whomever it is y'all are using.
Yes, ma'am.
And this is going to be because he's got the GPS device and it's more or less a furlough. What do we want to do? I don't even know if there's a bond needed for that. Just I mean, he's essentially, we've got the tracking on him, but he goes to the funeral. How long is he going to be? When would he return? We need to know that so that the jail can say he's got to be here by a certain day at time. If he's not there, then a warrant goes for his arrest because he's violated a court order.
Check out Friday, come back Sunday evening.
Yeah.
He leaves Friday, comes back Sunday. 48 hours?
It's the funeral Saturday, right? Okay.
48 hours. Okay.
What time do we want to release? And
What time does he get released on Friday? Do they need him?
Can they do Friday more? I think the family anticipated
About
leaving out
12 noon. 12 noon?
8 in the morning.
Okay. Okay. 8 o'clock in the morning.
Okay. And he needs to return at what time on Sunday?
What time is he going to be back Sunday?
Every time you need to have back, I'll break it first. Be honest. So
3 o'clock. Y'all are coming back on Sunday, right?
Yes, sir.
So is there some function Sunday morning with the family?
We would love to go to church.
Yes, sir.
Yes.
Well, can you be back by noon?
It might.
Yes.
Can we do 3?
2?
2 o'clock. All
Yes,
right.
2
2
o'clock.
o'clock.
Okay.
2 o'clock p.m. So the order is he's released Friday.
8 a.m.
8 a.m. must return back as a condition of your release, and it's
Friday, but what did you say? 3? What do we say?
Sunday 2. Sunday must return Sunday 2 o'clock. If not, then a warrant will be issued for the rest, and there'll be additional charges, but that won't, and it wouldn't help you with this case. But I'm sticking my neck out on this, and don't chop it off.
Thank you.
And it will be a release without a financial bond.
Yes, sir.
For humanitarian reasons.
Yes, sir. Thank you.
But
Friday, 8 a.m.
follow the rules. And then we need to get
Yes, sir.
this thing resolved.
Yes, sir.
But we're not going to wait for a trial. We're going to do a motion to revoke probation hearing first.
Yes, sir.
Okay. Okay. Do you understand what has happened today, sir? I mean, you're in a mess. Don't compound it. You can only help you by following all these rules, complying with the law, and not getting in I don't want to whiff of any trouble.
Yes, sir.
Okay. Because you made that promise to me when we put you on probation, and here you are. Now, you're presumed innocent, but this motion alleges not just one violation. It's got 8 of it.
Yes, sir.
And
Would I need to follow up with the jail?
I'm gonna give you something.
Tell ya.
I'm gonna send something
He's
to
got-
you, but I'll give you a hard
we got
copy of it.
we got 2 different drugs that he tested positive for. So I really only have a drug patch on him too. But I'm sorry, you made promises to me already, sir, that have come back to haunt you because on the drug screen, you weren't supposed to be testing positive, and you tested positive twice to 2 different kinds of drugs. You got 8 violations here. That's enormous for someone who's not supposed to have any. 8 only takes 1. You got 8 here that you're working on. So don't talk. Walk the walk. Do it. You're not doing what you promised you would do and what's expected of all probationers, according to this. So your promises aren't really working. You've got to show action. Positive compliance. And you lose privileges by getting into this kind of mess. This is a rare event we're doing here.
Thank you, Your Honor.
It would be catastrophic if you didn't perform well. Do you understand? Okay. That is all. All right. What do you want to do the next event though, Brittany?
We could set for the hearing, MTRP hearing.
Yeah, but you don't want to do that next week or so.
No.
4 weeks?
Yes, sir.
Okay, 4 weeks, MTRP hearing.
Okay.
Thanks. And we'll,
Okay.
Lacey, do I have anything else? Is that it? Did we clear the docket? What do we have this afternoon? Okay. We in recess. Everyone have a nice day.
Good morning, Your Honor. Good morning. All right. Janet Carraro?
Yep.
Good morning.
Good morning.
Country Meadow Apartments versus Janet Carraro and Christopher Carraro, 23C3425. This is a landlord-tenant case for non-payment of rent. As tenants, you do have the right to an attorney, so if you had any questions about the legal process or any possible legal defenses, you can be referred to legal services. There are some limited resources for rental assistance. Did you apply for any sort of rental assistance?
No, I only owe this month. I owe November's rent. I've been paying my rent by the end of the month every month because I got behind due to medical. I've said this over and over. At the end of October, I paid the rent. I talked to her like the first week of October. And she said, I was like, get the form on the 6th, and she's already added the late fees. And I'm like, well, then I might as well pay my other bills on time because I've already got these late fees. And now I got court costs again. And it's like, dude, November's rent will be paid next week. Like, I asked for the form Friday because it's before the 5th. And she said, oh, you already have going to have late fees and court costs. Also, I don't get any assistance. I don't try and get food stamps. Like, I try and, you know what I'm saying? Like, I try and do everything the way I'm supposed to do it. But I figure if you're already going to tack on late fees, then I'm going to pay my bills on the other ones that I can pay on time to avoid those late fees because you've already tacked them on there. Like, you know what I mean? At this point, it's so frustrating. And because I've been late so many times, she wouldn't renew my lease. So my rent went up, you know, to almost $1,400 now. Like, I was paying $1,300 with late fees and court costs every month. I've paid almost two months worth of rent in late fees and court costs in a year.
Okay. Mr. Morgan, what's the balance today?
I show 1476.50. That's inclusive of court costs. If I could just also
that's garbage.
Maybe for some peace between now and next hearing, you can speak with your landlord about waiving those costs after you pay X amount, whether that's November or whether it's the amount that we reach under a conditional dismissal. Those are still things that your landlord can work out with you and credit you for down the road. The court costs
won't give me any credit. She won't give me any credit because she could have just not done it because my rent would have been paid. Like, you fill out the paper, you don't get late fees, you got to pay your rent by the 14th. My rent would have been paid by November 14th if she'd have gave me the paper. Now she's tacked on all these extra fees. You know what I mean? It's $1,336 before all these fees. And now you're saying it's 14 what?
$1476.50.
Right. Now I won't have that.
Frustrating that there are.
Now I won't have that by this weekend because I still got to have gas to get to work next week.
So procedurally, we're going to adjourn this out to the 15th at 2:00 in the afternoon. That hearing will take place here in person at the 14B District Courthouse. So if you pay everything before then, as you know, you won't need to come back to that court hearing. But if you still have a balance, you need to be the 15th, 1 week from today.
And it's 14 what?
14B District Court.
No. How much is a total?
I'm sorry.
1,500? 1,500?
1476.50. I'm sorry, Your Honor, was that at 1:30?
2:00.
2:00, thank you.
Yeah. Okay.
So is that going to be posted on my door for all my neighbors to see again?
No, we'll mail it to you.
I don't even need that.
It automatically gets mailed out, but so okay. If you pay everything beforehand, then they'll dismiss the case. If you still have money, you just need to be out here to talk to the landlord's attorney when you get out here. Once you get caught up, I would suggest filing. If there's a form you can file, I would just file it.
That's why but that's what I'm saying. That's why I was trying to file it because I was caught up.
Right.
I was caught up on the 3rd, but because I had this court date today,
right,
she wouldn't give me the form. I was caught up.
I hear you. But if you pay that whenever you pay it and they haven't filed a new case, fill out the form as soon as you can. I'm just trying to smooth this out forward here. So okay.
I will. Thank you.
Okay, 15th, 2:00 in person. You're all set, man. Have a good day.
Thank you.